The Constitutional Court has dealt a blow to the National Prosecuting Authority in a judgment that has serious implications to close to 90 cases that involve the extradition of fugitives. The Apex Court on Friday upheld the unlawfulness of any extradition process not spearheaded by the Justice Minister.
The international stage of outgoing extradition requests entails sensitive diplomatic and foreign relations considerations, which fall squarely within the domain of the national executive. In other words, the international stage of outgoing extradition requests cannot be entirely subsumed under prosecutorial proceedings, and the separation of powers principle forbids the NPA from controlling the entire process.
This precedent-setting judgment comes after the NPA approached the Constitutional Court challenging a finding by the Bloemfontein High Court that it had no jurisdiction to try Moradi Cholota. Cholota, a former assistant to ex-Free State Premier Ace Magashule, was also charged in the multi-million rand asbestos case. As she was studying in the US at the time, the NPA led the process of her extradition in August 2024. Appearing in court in April last year, Cholota made a special plea to argue that the Bloemfontein High Court did not have jurisdiction to try her owing to the unlawfulness in how she was brought back to the country. Her lawyer, Loyiso Makhapela, cited the Supreme Court judgment of May 2024. Because the appeals court had found that the NPA leading the extradition process was illegal, Makhapela argued that this also ought to be the case with her client. The High Court concurred, leading the NPA to approach the Apex Court, which ruled on Friday that while Cholota's extradition was unlawful, this did not invalidate the criminal proceedings against her, upholding the NPA's appeal.
In a unanimous judgment penned by Theron J., the Constitutional Court finds that the Cholota matter engages its constitutional and general jurisdiction, as the matter raises both key constitutional issues and arguable points of law of general public importance. This court also finds that direct leave to appeal should be granted, as it would be in the interest of justice to finalize this matter.
Given Makhapela's reliance on the appeals court judgment before the High Court, the NPA, in its application, also made an application to challenge the Supreme Court of Appeal's findings. The state was, however, unsuccessful.
In the Schulz matter, the applicants seek condonation for the late filing of their application for leave to appeal. Condonation is not there for the taking. The applicants filed their application for leave to appeal approximately 3 months after the 15-day deadline period prescribed by the rules of the Constitutional Court had lapsed. A 3-month delay is substantial, and this court has refused condonation for shorter delays in the past. The explanation for the delay proffered by the applicants leaves much to be desired. They blame most of the delay on their misunderstanding that the Department of Justice and Constitutional Development intended to launch an appeal.
Despite the victory in the Cholota matter, the NPA now faces possible appeals in all matters where it led the extradition process. In its court papers to the Apex Court, the NPA had indicated that close to 90 cases would hang in the balance given the retrospective nature of the judgment that only the minister can lead extradition applications. NPA National Spokesperson Tunzi says the prosecuting authority will meet and strategize on how to handle the possible fallout. With the asbestos case set to get underway on Monday, the trial now looks likely to be delayed, with yet another trial within a trial expected to get underway at the High Court to determine Cholota's special plea that it has no jurisdiction to try her. For Newzroom Afrika on Channel 405, I'm Juniour Khumalo at the Constitutional Court.